Goedemorgen allemaal. Ik begin in het Nederlands voor alle Nederlandse gasten en degenen die in de livestream kijken naar deze paneldiscussie over slaps. Maar dat doe ik vooral om aan te kondigen dat de hele panel in het Engels zal plaatsvinden, zodat ik nu kan switchen to English.
Thank you.
So a very hard welcome to all of you interested in the topic we're going to discuss today. My name is Leon Willems. I work at Free Press Unlimited, the Dutch press freedom organization. And we're very happy to host you here for this session about SLAPS. So what is SLAPS? It's a typical acronym for policy geeks in Brussels. You can say it's like a slap in the face. But the official acronym says Strategic Litigation Against Public Participation. Now, that is the maximum pressure that legal inhibition can work out by preventing journalists from doing disclosure about malpractices. And that is why press freedom organizations think the EU should act against SLAPS and create a directive. That is what we're going to discuss today. But the best way to talk about SLAPS is to talk about legal intimidation, preventing disclosure of public information that is needed for improvement of public access to discussion, etc. And when we started this discussion in Free Press Unlimited, together with the partners we have here, Article 19, the CASE Coalition, the Coalition Against SLAPS in Europe, and the Media Freedom Rapid Response Group, which is a consortium of press freedom organizations that act for better press freedom in Europe, I couldn't help but think a couple of years back when we started discussing violence against journalists in Europe. And everybody said, including editors-in-chief in the Netherlands and abroad in France and Germany, well, that doesn't really happen in Europe. And then we did surveys, and we found out that actually people go to demonstrations, photographers, with bulletproof vests. We were thinking, what, in the Netherlands, this is happening? We heard about incidents where people are being intimidated and prevented from taking photographs of public events. And that is when we started talking to the Dutch Union of Journalists, who were also concerned about all these facts. And that is when we started to reach out to the government and say, we need to do something about it, and we created Press Safe. It's a little bit, we have the same feeling about SLAPS at the moment. It's something that a lot of people, but that doesn't really exist in the Netherlands, or it doesn't really is a big problem. But of course, we know that when Daphne Caruana Galizia was murdered many years ago, part of the problem was that there were 47 lawsuits in Malta to prevent her from publishing corruption information. So there is a tendency, there is a trend in the last years in Europe that legal intimidation exists, and that it actually leads journalists to think twice before they publish some information. Now, questioning journalism truth is always a good practice. Journalists do an investigation, and then many years back, and that is pluralism, other journalists said, well, I want to see what you research because I'm not sure if what you're saying is actually factually true. And then you have a discourse, you have a debate about facts, etc. But this is different. This is where companies or states basically try to intimidate journalists to even disclose an investigation. And there are many recent events where we are getting close to that. So SLAPS, a strategic litigation process where a company tries to prevent journalists from disclosing something, is like the summum. But legal intimidation starts earlier. That is what we're going to discuss about today. We have a panel led by Thomas Champico, the legal advisor of Free Press Unlimited, Sarah Clark from Article 19. We have the Dutch negotiator on the European directive here, very welcome, and Thomas Bruning, who will disclose a recent survey that was done amongst Dutch journalists. I can say one thing to start. 85% of the respondents to the survey said they don't know the term slaps. But 83% said that they recognize the existence of legal intimidation. But Thomas will go deeper into that in the panel. And I hand over to Thomas after we watch the video that is an introduction, which we will start now. Thank you very much for your attention, and I hope you have a good meeting.
My name is Okke Ornstein, and I was slapped for investigating fraud and corruption in Panama and in the Netherlands. It's almost inevitable in a country like Panama that you stumble upon and then focus on corruption, because it's a country where you find corruption at almost every level of society. Montefriesner is a Canadian, I can safely say, career criminal. He's been convicted in Canada and the United States of everything from money laundering to financial crime to fraud to arson to assault and everything in between. And at one point he moved to Panama and started a number of companies there, one of them being a company that was issuing prepaid credit cards, or so they said. And again, I got a lot of information from within that company. This was just an enterprise that was facilitating money laundering and probably advanced free fraud. And I wrote extensively about that. I followed his activities in Panama. It was very quick that I think the first criminal complaint came in for criminal defamation, and then another one. I think there were a total of 3 just by him. And I later found out that he and his associates were also planning to file similar complaints in other jurisdictions. So it became a sort of libel tourism, as they call it. So they went to Croatia, they went to Russia, they tried something in the United States, and just to make my life miserable, and tried to stop me from publishing about it. But thanks to the Dutch government and a number of press organizations, it was only 1 month. But that made that I left the country because I did not feel safe anymore to continue reporting there. The most recent example is another one of his associates who was involved in a foundation that Friedner started. The foundation had members that were hanging themselves out as Panamanian diplomats with fake passports and all. And this Dutchman was in the board of that foundation. And when I mentioned that simple fact, that was already enough for him to sue me, and that he lost that case rather spectacularly. But even so, he appealed, which tells you also a lot that it's more about harassing me than that there actually is a case. In a civil case, you don't have that first check. So anyone with a gripe against a journalist can file a civil case, and then it goes to court, and you have to hire a lawyer, and you have to file the papers, and you have to do this, and you have to do that, and before you know it, you're 10,000 euros further down the drain. I recently started thinking, well, you know, maybe it's just not feasible to publish these kind of stories as an independent journalist. And if you don't have the backing from a big media organization, and I don't, I'm a freelancer, then a lot of this work becomes very costly, dangerous, fatiguing. But they can be serious about winning these cases because they're not going to win. It's just bullshit.
So, welcome everyone. After this powerful statement by Okke, unfortunately he couldn't join us today. We're going to start the panel discussion for this morning. So I want to invite the panelists to join me up front. Welcome Sarah Clark. She's the director of Article 19 Europe. She has led the work of the organization in Europe and Central Asia since 2019. And their work to defend freedom of expression involves advocacy projects with local partners across the region. Sarah sits in the steering committee of CASE, the Coalition Against Slaps in Europe, and MFRR, the Media Freedom Rapid Response that we have here. She's also an expert on freedom of and one of the experts of the Free Expression Center at Columbia University, and she has also worked with the UN, UNHCR, OSCE, in a multiple positions, and she also has worked around asylum and forced migration. Thanks, Sarah, for joining us. We also have Thomas Bruning present. He's the Secretary General of the NVA, the Nederlandse Vereniging van Journalisten. For those who don't speak Dutch, it's the Dutch Journalists Association. He's a director of Via Media Publishing Company. He founded the Dutch Press Freedom Foundation, where he continues to work as a board member and secretary. He's currently chair of Persveilig, the safe press platform of the Netherlands. And he also teaches as a visiting professor a number of journalist courses in different universities. Thanks, Thomas, for joining us. And we also have the presence of Jan Kostijn-Diebe. He's a Justice and Home Affairs Counselor at the Permanent Representation of the Kingdom of the Netherlands to the European Union. That's a mouthful. He represents the Netherlands during different negotiations on EU legislation, and including the current anti-SLAPP legislation that we're going to discuss today. He also worked as a lawyer for Blackstone Westbroek, specializing in civil law, and has worked as a researcher at the Mollegraf Institute of Private Law from Utrecht University. Welcome, Jan Kostijn. Thank you very much for joining us. So before we jump into the panel, a few rules of engagement for the panelists and for the lovely audience here and the people watching online. Well, first of all, it's a very sometimes gruesome and worrisome topic, but let's try to have a candid conversation and let's try to avoid as many buzzwords or jargon as possible. That's going to be a challenge. I'll kick off with some questions, and then we'll have a Q&A part at the end of the discussion. We're going to be working, the panel is going to be until 12, but for those who have joined us here, there's a little lunch afterwards, and you're all welcome to stay. And for the people watching from home, at office, or wherever you are, please feel free to leave your questions on the chat box. We will be looking at them. Some of our colleagues are here checking your questions, and we'll make sure to pass on the questions to the panel if needed. So thanks again. Welcome, everyone. I want to start the conversation by posing a question to Sarah. Leon already introduced a little bit the topic, explaining a little bit what SLAPPs are, but I want you to sort of come back to the topic and please explain us what SLAPPs are, who is being targeted, and why should we be worried about it?
Thanks, Thomas. So SLAPPs are, the term SLAPPs it's a US legal term, which is why I think it poses some trickiness for civil law jurisdictions, but it looks at lawsuits and legal actions. So we also deal a lot with what happens before trials, so legal letters threatening suits, etc., that are usually taken by the powerful or wealthy. So in terms of plaintiffs, and we've done a lot of research as part of CASE, we've documented 570 cases across Europe. They tend to be taken primarily by wealthy business people. So about 35% of all of the cases are taken by business owners, corporations, often targeting environmental campaigners or journalists investigating corruption, but also by political figures. So politicians are the second biggest category of plaintiffs, who usually take them against journalists in defamation proceedings. We don't have a definition that we use when it comes to SLAPPs. We usually look at the hallmarks of these cases. So it's each time it's an appraisal of, okay, who's taking the cases. The defendants, as you say, are primarily journalists. So in the case research, around 80% of the defendants are journalists, but we also see activists, LGBT campaigners, academics. In Poland, we see academics in particular are targeted, and smaller whistleblowers, smaller categories, but still very very important watchdogs.
Yeah.
So case is very very focused in our work at the EU that this anti-SLAPP directive should cover all groups of civil watchdogs. In terms of the laws that are used, again, in Europe, it's primarily defamation laws. But we also see the rise of laws like privacy and GDPR being used to prevent publication of materials or to delay, real delay tactics, beyond the point where the story is relevant anymore. So we're also quite concerned, for example, in Hungary, we see a lot of abuse of the GDPR provisions. So tackling defamation alone won't solve this. So that's kind of something else to keep in mind. Okay, made a great point, and we often say this: the point is not to win the case. And he said, why would they take this? They can never win it. The process is the punishment. So a lot of these cases go on for years. They're unbelievably expensive to defend yourself. And as any journalist will tell you, while you're putting all of your effort into fighting the cases, you're not doing your work. And that's the point. Most of the time, the plaintiffs have deep pockets, so they can well afford to take lots of cases, to hire expensive lawyers, and that's not what it's about. But in terms of recouping the funds at the end, very few editors are going to be okay with you embarking on a 10-year case, and that's why so many people are put under pressure to settle, to take down content or investigations. And often the net result, the chilling effect is, we just had a conference on this in Ireland, there are quite a few very wealthy, powerful individuals who are simply now, untouchable, because editors will not let journalists go and report on these individuals because of they know that these guys will routinely
continue. Yeah. And tell us a little bit about the amount that normally is requested in these lawsuits.
I mean, it depends country to country. So we see like a huge range in terms of the costs. Britain and my own home, Ireland, remain the absolutely most expensive jurisdictions.
Yeah.
In both countries, you have to defend yourself starting in the High Court. So to defend yourself in both Britain and Ireland starts at about €350,000. Yeah.
And the lawsuits normally, what are they requesting in terms of damages?
In terms of damages, we see everything from like Italy, where you have a cardinal in the Vatican requesting €10 million damages, to often, sums in between tens and hundreds of thousands. But I think the bigger picture is that they want stories taken down, they want materials censored. And that's the bigger cost.
So that's the intimidation aspect of it, right? Like
absolutely.
Just being always afraid that you can lose a case in court. And
and I think one of the really kind of big things and the big features is that so much of this takes place behind the scenes.
Yeah.
So when Daphne was killed, the issue of slaps really came to the fore in Europe. Daphne's family made a really strong call to journalists to come out and talk about this issue. But for many journalists, it was very tough because, they had taken down their own material out of fear, and even as in the days after Daphne was killed, lots of material started disappearing from Maltese websites because journalists across the island were being slapped. So, one of the key elements of case of what we've tried to do is to really, make it okay for people to talk about either, where they might have removed material, or what we really strongly encourage is to publish the legal threats that they're getting from law firms.
very scary to come in public and speak about
Super
it. Yeah.
scary. Yeah.
So you already
Mm.
painted a very good picture about what's been going on in Europe and the research you've done. I want to zoom in into the Netherlands, and I want to pose the next question to Thomas, who's joining us today. Thomas, we know that the MBA and Persveilig conducted a survey recently about legal intimidation against journalists in the Netherlands. Can you tell us a little bit more about the findings, how it was conducted, and your impressions about it?
Yeah, well, the idea to focus on the legal part of intimidation, pressure, came up from an earlier research we've done, and this research was much broader. It was about physical violence. It was about all kinds of violence, and we saw that in this first research or the earlier researches we've done, that legal pressure was really mentioned not only quite a bit in this earlier survey, but also people told us about individual experiences in the survey itself. So we thought, and especially with the directive coming up, it was a good moment to focus on this legal part. And what we found out, and which was interesting, is that the response to this research was quite high. We have about 8,000 members in Holland, 8,000 professional journalists. And when more than 10% respond to a survey, they get a lot of surveys, they get a lot of email. It says something that it's on their
Urgency,
agenda.
yeah.
So more than 850 journalists responded. And also we put an extra research or an extra survey to the editors-in-chief. And I think it was about 90 editors-in-chief that we reached out to, and 36 responded. So there are even more than 30% responded. And we do a lot of surveys, and I can tell you that these are high percentages. And as Leon already mentioned, a lot of the people who responded did say we are familiar with this, and 50% experienced at least once over the last 10 years or something a case where it came up to a civil court, or to at least being addressed to go to court. So you see that this is an issue. And of course, at the same time, you can say, when you work as a journalist, it's not always pleasant for everybody who's involved, and you touch upon privacy issues, you touch upon defamation issues, and so you could say, and it's part of the job, and that some people or some companies will not be pleased with the things you are intending to publish. But at the same time, we see that it's more in the heads of the Dutch journalists as well. And I think, as far as my experience goes, that the last few years, sometimes you see really incidents like the one with Okke, that you can really say, okay, this is what we call the definition of a slap. And we saw a couple of these incidents before, with a telecom company here in Holland, and with also a Dutch reporter reporting on somebody in Africa. You see so sometimes it's quite easy, and sometimes it's more like the threat, but already the threat can be very useful. And especially because the situation in Holland, and you see it also in this research, is that less than 50% or more than 50% of the respondents work as an independent journalist, as a freelancer, and they feel much less safe in their work, also when it comes to these legal pressures. And they experience, and especially they experience it when they have to promote a story, let's have a story on this, or let's have a story on this. Then they think already in their heads, well, when I try to get this story done or sold, then I have to think about the implications for and I don't get the assignment. So it should be. So it's very important that this part of Dutch journalism is being protected, because in general we didn't see a lot of cases that came out at this research that you can evidently say it's a slap, but we do see this legal pressure.
Yeah, it's a difficult topic indeed, and when to label a case of legal intimidation as a slap or not might be tricky. But as Sarah was saying, there's very clear criteria to know when a slap is a slap. And Sarah, I want to go back to you. Can you please perhaps tell us a little bit more about what does actually mean to be a victim of slap? We already heard, okay, but it's not only money, right? But I can imagine the mental aspect, the psychosocial aspect of and the stress that creates to be threatened with a lawsuit might be difficult, right? You're in touch with.
It's extremely difficult. We see, the strategy is to really isolate people. We often see that plaintiffs go after freelancers. They go after journalists in the capacity of comments that they make, maybe like for Carol Cadwalader, like on a talk, rather than going after the newspaper. So we see.
So the easy targets.
You kind of hive off the journalists from the institution, and then it's on them to front the costs. We know loads of journalists who been at risk of losing their homes. We see in Poland, we've had journalists who've lost their jobs because they've been slapped, where newspapers feel, look, this journalist is drawing too much, negative attention from high-level politicians, or who, that we don't want the legal risks. We've talked a lot about things like insurance recently, that like newspapers can lose their premiums on insurance, and that's been a big issue in places like Belgium.
So it's a cascade, right? It's not only the lawsuit itself, but it's also like a huge damage that's caused to the journalists, to the media landscape,
and I think just overall, you see this. It's this like wearing down of the journalists. I mean, Daphne said in the days before she was killed, when she was explaining the cases she was facing, she said, I feel like they're trying to fry me alive through these cases, because it's the money. Her bank accounts were frozen. That's where she was going when she was assassinated. Obviously, Daphne's case is extreme.
Probably the worst ever.
She's the most slapped person in Europe, but I think you can see a lot of the different hallmarks there, and I think we kind of see that a lot of the time, when we're talking to journalists who are being slapped, it's a bit like a therapy session, because they finally can see, okay, this is what's happening to me, this is what's happening to other people, I'm not on my own. And some of the really the really important supports that we've been able to give as part of MF4R and through our wonderful partners at ECPMF is legal support. So we fund the lawyers for a lot of journalists facing slaps, and that's a significant weight off people's shoulders. Yeah,
wonderful. So that's a first defense mechanism, let's say. So now we have established that slaps are quite a big problem in Europe. The Netherlands is coming up that there's some signs that we need to start to get worried about. And with that on mind, I want to talk, put the first question to Jan Kostijn, who's gladly joined us today. What's been going on in Europe? What are the solutions that are being discussed to address this problem?
So I think in Europe, in Brussels, we have seen two pieces of legislation that have been put forward to tackle the issue of slaps, or actually one piece of legislation and one recommendation. And they try to look both at getting more information on how big is the problem, where is the problem, how do people respond to the problem. And that is something that each and every member state, like the Netherlands, has to implement and try to tackle. And then the second one is a specific piece of law, this anti-SLAPP directive, and that tries to solve this issue of abuse of proceedings, because that's actually what we're talking about. This, I don't need to win, I just need to take to court, and that's already enough. And they've tried to put forward some solutions to solve that issue. So those are the two things that we see happening at a Brussels level. The Netherlands, from the start, has been an active supporter of these two initiatives. I think even if we're happy with the Dutch situations, because we might not have the evil slaps, but we might actually have the legal intimidation. Even if there's only one slap, that's already too much. And I think we should be very careful in pricing ourselves rich, as we say in Dutch. So I think in that sense, we have been really looking forward to negotiations on this topic. What we have been trying to do as the Netherlands is to ensure that what was put forward in Brussels would actually be effective when implemented in member states. And I think this is always the challenge when it comes to European legislation, is the question, what issues can you solve at the European level? What issues do you have to solve at a national level? And especially when it comes to procedural law, there's a huge diversity between member states. So it's really hard to find a one-size-fits-all solutions, and we have been trying to ensure that the solution that is put forward actually strengthens the situation in the Netherlands and in other member states.
Great, thanks for that. And I want to go back also to Sarah. Sorry to bring you
No, please.
always in. You've been following up the negotiations. Can you tell us a little bit more of what you know about it? We've heard Jan Kostijn, but also from civil society perspective, what have you seen?
So we have seen this Swedish presidency compromise draft. So that is the latest draft from the negotiations. Is that fair to say? Of the anti-SLAPP directive, and unfortunately, some of the pillars that we as CASE have really advocated for have been removed from the draft. So we are very concerned to see the Article 4, which define matters with cross-border implications. So a lot of these cases, when we haven't even got to the UK, a lot of these cases, that would be a third country, but a lot of these countries have what we would call cross-border implications. And that was one of the real key issues for us, that they would that would remain in the text. We're also concerned about the very high threshold of the new definition of what a SLAPP is, and that would be that they are manifestly unfounded, or a claim which is so obviously unfounded that there is no scope for any reasonable doubt.
So it's a very high.
So
high
it's incredibly
standard, yeah.
high. And most countries already have procedures to deal with such a high level of manifestly unfounded. So we're quite concerned, because that threshold then leads to all of the protections. So you have to reach that threshold in order for the early dismissal of such a case. And the early dismissal, we talked about how long these cases go on. Early dismissal of cases is like the key protection. It's that a judge can look at the case and say, this is a SLAPP, and we can end the process quickly. So and then finally, Article 15 on the compensation of damages has been removed, and we've seen the substantial watering down of other measures designed to protect individuals facing SLAPPs. So I would say that we've responded a lot in the last couple of weeks to the proposal. We're working closely with the European Parliament, because there will be a trilogue on this text between the Parliament, the Commission and the Council. got that right, around the text.
I thought no jargon.
No jargon, trilogues. There'll be a discussion. So we still have room to push for a stronger text. I think, when you come back to Daphne, this law is colloquial, is known as Daphne's law. As it stands in this compromise text, it wouldn't protect Daphne from any of the cases she was facing. So that's a huge worry, and that's the concern for us.
Yeah, you have already started to spell out some of the protections around the directive that was already published last year. Thomas, I want to get back to you. What is your reaction to this? What's the reaction of the MVA towards what's going on in Brussels? Do you think that what's being proposed is gonna be helpful or not?
No, I do agree with Sarah that the first draft was much stronger, and I think that I hope, because of course at our level we have the European Federation of Journalists, who is involved more than we as a single country, but we do hope and we do emphasize that Holland should be an example, and although we do see also coming out of our research that it is felt as an issue in Holland, I very much feel that we should be in the forefront and expressing the worries and finding solutions for these worries in countries in Europe where there is not such a good state. And we do see also, when it comes to Dutch cases, that this cross-border component is usually, you see it with Okke, you see it also with the case of Sanne Terlinge, who worked for One World and made a story in Africa. And so you see often that, and because all the big research projects from journalists are becoming more international, this is something we should also be aware of. I mean, the good news is, of course, that in this international research project, you see that more journalists or more titles are working together. So this means that you have more power to cope with this pressure. But at the same time, it's very easy that a case also comes to another country, and you can get a problem out of this other country, other European country.
Yeah, so the Netherlands is not isolated, let's say.
Netherlands is not isolated. The Netherlands should be an example. And in some cases, we are not the example when it comes to information law. But in this case, I think up till now, also because we have some extra defenses built in here in Holland, we have this legal advice bureau here in Holland that helps freelance journalists, giving them advice in this first stage of legal pressure. And we have the Persvrijheidsfonds, which is a fund that can also help when you are confronted with a legal court case. So we have I would say quite a good situation in Holland, but we should be proud on it, and it's not something we should take for granted. I know it's not going to happen, because we saw also in the past that we did have some of these slap cases here in Holland. We have the case of Peter Oosthoorn, but several titles that were confronted with law cases until the highest court here in Holland by a company called Pretium. And we did really hear that these titles were starting to avoid just the issue of Pretium. And then you see that the strategy of such a company works out. It's just like you describe in England or in Ireland. If you really have the feeling, okay, if I'm touching upon this kind of story, I will get into deep problems. Yeah.
So the time to implement more protective and preventive measures is now, right?
Yes.
I think that's a clear call to action to the Netherlands.
One really good thing that is retained in the text is protection from what we call third country decisions. So decisions from the UK, from outside of the EU, they won't be enforceable.
Mm-hmm.
So if
have I got that right?
Just
Yeah.
finish your thought. I'm just
Just looking to you. The provision around. So if you were sued in Africa or Panama, those there.
Yeah. But the thing is, of course, especially when it comes to the UK, the moment you visit the country, you have another problem. Yeah.
So that's very clear. Right? So even journalists, so the protection is important because it also protects journalists from decisions being made outside of the European Union.
Yeah, and we see a lot of those have sort of gone through. We've had like the most extraordinary cases being brought in London.
So that's also a reason.
So we'd like to obviously see that retained.
Yeah. I want to go back to Jaco Stein.
Can I react to both
Please.
statements? So I think first of all, we had the pleasure of already discussing some of these topics, and it really helps us. It really helps us. I think also the work that Kees has been doing on this is great. I think actually a lot of the incentive for this initiative has come from society organizations, which I think is a great example that it still works, the mechanism. I am more optimistic. So I think actually what we see happening in Brussels is, to our understanding, a strengthening of the instrument on important aspects. I wasn't allowed to go into detail, so I won't. But we feel that there are some good things that we were able to achieve there. And I think with regard to the topics that you qualify as disconcerting or something that you would fill in, my takeaway from the discussions that wasn't very much done as a watering down or trying of weakening of the instrument, but it was very much a different discussion, a discussion of what can you do at a European level and what should you do as a member states level. And this is always a horizontal discussion in Brussels that might sometimes be dissatisfying when you try to achieve an aim that everybody clearly supports. But then on the other hand, that is kind of relevant because as a representative of a member state, I have to make sure that whatever Brussels does doesn't end up being a precedent for other files where you might necessarily not agree on the aims. So I'm more optimistic. I think when we look at the Dutch situation, what I really took away from the survey is I personally took big pride in what we have in the Netherlands with regard to Bali-persveiligheid and the persfront. So the support that we have for journalists. And actually a lot of what the Commission has been doing in its recommendation, so this other piece of legislation, was based on the Dutch system. So I was there in this negotiation, hammering my own drum, saying how well it was all done in the Netherlands. And then I reached the survey, I read it, and I see that actually a lot of journalists, 55%, like you said, are self-employed, so they don't have the backing of a strong newspaper. A huge percentage, I think like 80 to 90%, isn't aware of these Bali-persveiligheid, of these support funds. So that means that actually the protection that we have in place isn't on the radar. So I think there we should really take heart, and make sure that we keep providing journalists with the protection they need and the protection that we already have. So those are two replies from my side, and that was just.
What I wanted to ask is, you've been involved in the negotiations, and I mean, of course, you work very closely with your colleagues from the ministries here in the Netherlands. And I wanted to ask you about what are the major roadblocks, that you see in the negotiations. You already mentioned a couple. So why it's been so difficult to come to a solution or to?
Well, actually, I think I'm not sure if it's there were difficulties in that sense. Like I said, I think what I saw was across the board there was huge support for the aim of the instrument. When it comes to the solution, like I said, there's this difficulty of competence. What can the EU do? And the difficulty of the diversity of national procedural law, because we're talking about a procedural law solution. And for example, one of the things that the Netherlands was a big proponent of was to allow a judge not only one moment to consider something a slap, namely at the start, and afterwards the evil oligarch is free to do what he or she pleases, but we wanted the judge to have this option during the whole procedure. So maybe something that starts out looking innocent halfway through the procedure is clearly a slap, then you still want the judge to have this ability. Now, for other member states, this was really problematic because they have different systems. They have a common law system or a partial common law system. So we tried to figure wording that would fit everyone. I think, for example, the manifestly unfounded threshold that you mentioned, for us, that wasn't necessarily a necessity. For us, the emphasis was more on the abuse of procedure. Apologies for the technical terms. But then again, we saw that for other member states, this was a really important word because it fit their systems in the thinking that they already had. And I think what we should keep in mind here is, or maybe that's actually the answer to your question, the big challenge here is to balance two essential fundamental rights, which is the freedom of expression with the access to justice. And we all have in mind these horrible cases where everybody knows this is an evil oligarch. Like this is not about some sort of...
It's not about justice.
No, this is just about power, revenge. So those are the easy ones. There, freedom of expression prevails. But then, of course, we also have other examples. I mean, we have vloggers also here in the Netherlands that have had a interesting approach to journalism with like types of information that were clearly unfounded and not necessarily an addition to the public debate. And you wouldn't want those people to be kind of like protected against the correction of a justified rectification. So I think balancing out that freedom of expression and that access to justice, that has been the challenge. The Commission already did a great job of that with the help of CASE. What we have tried to do is to fine tweak it to ensure that it fits each and every member state. And from the Dutch side, we try to strengthen it.
Okay.
But, yeah.
Well, good that we have you there in the negotiations to make sure that commitment to this balance act remains. So I want to ask the audience if there's any burning questions that you would like to address the panelists before we continue. Yes?
There is a question from the online audience.
Sorry, where's the microphone? We have a question here from the audience online. Thanks, Leon.
So a question from the online audience. One of the recommendations from the Commission is that countries monitor slaps against civil society actors on the national level. The Press Safe survey is a first step to show that legal intimidation towards journalists is real. So how does the government plan to coordinate broader monitoring of such threats against civil society?
Okay. Please.
I heard government. So I think this is a very good question, and indeed we had these two pieces of legislation. One is a recommendation, the other one is this directive that we were talking about. In this recommendation, so what member states have to do themselves, what the Netherlands has to do, there's this request for gathering information. I would like again to highlight this difference between slaps and the legal intimidation that we saw in the survey. So these are different concepts. I think actually in the CASE report, you did a really great job of the filter that you can apply to legal intimidation that will leave you with the slaps, but there's several layers of negative ways of influencing the freedom of journalists. I think what the Dutch government will take from the recommendation and also from the survey is this need to first bundle all the various support that is already out there, and then to more clearly bring them under the attention of the groups that can benefit from that protection. I mean, again, I think if people don't know that there is a place where they can go, then we failed in providing them with that place in the first place. What you've mentioned, or what the request or the question is about, of course, is here we are talking about journalists. Public participation is a broader term, and this would mean that we would be looking into broadening this type of support for larger groups, or at least when it comes to the information gathering. However, this is also a challenge because concepts like public participation are very broad. I guess under the current directive, anybody with a Twitter account would be a public participant. So it's hard to distinguish between the various groups in that sense.
Thomas, I saw you wanted to react also to the question, or?
Well, no, I think Jan is right that we should work still on the visibility of the Bali persvrijheid to work in a good way. But I especially want to say that I think the research we've done has still another dimension that we didn't dive into. I mean, we still have to. I think more than 80 respondents said they want to talk more about their insights, because sometimes you also see, and I think Sarah touched upon this as well, that they just don't want to talk out in the open about some because they're still working on a case, or they so we have to see what's still under the surface when it comes to real SLAP cases, or to the more problematic cases. And you see it also at the level of the editors in chief. They will never publicly admit that they will avoid certain topics, because it's just not done, in journalism. But we do know that these kind of cases also exist on a Dutch level. So this is, and I completely agree with Jan that it's really the balance between these two rights. I mean, we really have to be aware of the fact that especially, let's say, the general public or the smaller companies should have this access to justice as well. I mean, there's a big responsibility from the media when it comes to publication, or you can so we should be aware of that. But it all comes down to the idea of, well, is there a sort of balance in place, and is the access to justice, but also is the access to justice on the level from being free to publish, is this is this in a healthy state, so to speak?
Yeah, I think it's helpful just when we are talking about this this balance, it's to come back and look at the abusive nature of the proceedings. So, no one is saying you should not have access to take defamation proceedings. We're very
you have the right to protect your reputation and your business. Yeah,
absolutely. That's not what's at issue. But you do not have the right to abuse legal systems in order to silence others. So, and that's again where you come back. I think sometimes, in particular from the defamation bar, we get told, well, you just say everything. All defamation cases are slaps, and we don't. We're pretty careful about the ones we characterize as slaps, but you've got to look at the abusive element.
Yeah, and I think also
because that kind of clears it up. We're not here to deny access to justice. Yeah.
No, and I think another piece of the puzzle is the right of the public to know, right?
Exactly.
Access to information as well. So not only freedom of expression from the journalists or the published those engaging in speech, but also the people that's on the receiving end, right? Of important information for major debates of public interest. I want to check if there's. Oh, you wanted to comment? I wanted to. Yeah, questions.
Yeah, I have a question about how different actors can help to tackle slaps. So specifically, what are maybe the most efficient ways for NGOs to help tackle slaps? But also, how can NGOs and governments work together in this? And maybe also, what is the role of journalist unions like the NVA? So how can we work together, and what are the different ways that they can tackle slaps?
Well, I think we work in a good way together with Free Press Unlimited when it comes to the international level, because what we see sometimes is that journalists have problems not here in Holland, because then we have lawyers in place and we can give them legal advice. But when it comes to an international situation, then it can be very helpful that there is already a fund in place, that they can get legal advice in this country itself, and that there's also a sort of network of NGOs that know who is a proper lawyer to defend the case in that specific country. So this can be a very good way of looking at the broader picture and the broader problems that journalists face, especially when it comes to an international level. And then we have Article 19, and I'm not sure we didn't work together still, but
We
only
do on our Netherlands
only an
working
advisory
group,
level.
yeah.
Yeah.
I would really pitch working with CASE and with the Media Freedom Rapid Response. MFRR, we can provide legal support, so for local journalists. And then the work that we do at CASE is really around advocacy. So, comms around the case, so documenting it, and then doing advocacy towards the government. So we will register it on the Council of Europe platform for the safety of journalists, and we can, conduct advocacy with the relevant actors. Some of my colleagues here are from Poland. They go to cases, they go and monitor cases, and are there in the room, in these like extremely difficult cases for journalists. And then we really try to connect the victims of slaps. So we do a lot of we've a lot of meetings and conferences and plugging people in. So we have national level working groups. I think we've about 12 at this point across Europe. So we would maybe invite the person to come and speak at one of the kind of monthly meetings. And then, we're a coalition of about 100 organizations, so we can really tailor the support that the individual needs.
Yeah. So the call to action is for people to come forward and get in touch with you. Article 19, Free Press Unlimited, MVA, clear. Looking at the time, there's time for one question before we go to final remarks.
Thank you for a very interesting presentation. It feels as such an injustice, and what can you do more to discourage slaps? And I understand a lawsuit is not bothering such a big firm, but reputation damage or smartgeld, I don't know what the word in English, to discourage, because it's where should you start? If they have 5 countries where they slap, can you also then say, well, then this company should be fined or anything like that?
Yeah. So we do.
No, I'm not a journalist. I work with Oxfam Novib, and I'm currently the chair of the Breed Mensenrechtenoverleg.
So some of this is a key point. So we're trying to approach and toxify the taking of slaps in the same way as big tobacco or other kind of attacking the brand. We have a brilliant slap Eurovision Awards. So it's a kind of a joke, but we've got a huge engagement. I think about 150,000 people voted this year. So we award it's a spoof, but we award like the slap politician of the year, slap business of the year. So and we get a lot of media pickup to just show like who's taking these cases. So it's so that's what we're trying to do is like very creative campaigning. Against the likes of like Bolloré in France. You've got like really big routine slappers in a lot of countries. So that's
to put the bullies a little bit on the front line.
And so to just give much more. There's a lot of public and journalist education required here. People still don't know what slaps mean. But I could see the shift even just in my country, in Ireland, after a number of high-level politicians started taking slaps against the public broadcaster and against others. And it went from a case of like nobody knew what slaps were to Mary Lou McDonald, the head of Sinn Féin, being nominated for this award. And it was like all over the press in Ireland, and it was a very funny moment where the political party didn't understand that it was a spoof, and they were like, "How do we accept the award?" So we were laughing.
They would gladly go and receive the award.
Yeah, but it really, it was very good for me because it went from a position where like nobody understood what we were up to on slaps. Just suddenly everyone's like, yeah, that's the thing they're doing, you know. And it's that kind of thing that can be useful.
I completely agree. I think creative solutions is the way to go here. I think one of the things that we saw as an important limitation of what was possible at the Brussels level is that the solution chosen by the Commission was a civil law procedural solution, which means that you're very limited in what you can implement. For example, penalties or prison or whatever for these slappers is not possible. That's something of a different field. But I think equipping judges with the tools to come with creative ways of disincentivizing is the word that we use then, this type of behavior is actually one of the things that we try to do. And amongst them, and I agree with you here, is for example, forcing a slapper to publish in a newspaper a piece that says, I was a slapper and I'm very sorry and I should have never had done this, because often reputation is what is the best way to hurt these people, because money is clearly not the issue for them.
No.
Yeah.
Thanks for that. Looking at the time, I want to give you a chance to make final remarks if you have them before we wrap up. Sarah, Jan Kostijn, Thomas.
Maybe just to say, you know, it's 5 years now since this movement started, and it's just been extraordinary to go from a position where nobody knew what a slap was to the Case Coalition and having a directive on the table. It doesn't end here with the directive. You know, we see that national level legal reform will be crucial. And just to say that we're up for the challenge, you know, and we see this movement has grown exponentially, and we've a long way to go. But join us, and hopefully we can stop this. Yeah.
Thanks, Sarah. A bit of hope.
I'm just going to support that positive note.
Yeah, me too.
Yeah.
Well, with that, with that in mind, I want to thank you all. Brilliant minds, brilliant discussion. And thank everyone for joining us today, and the people watching through the live stream. Thank you for joining us today. And a big applause for the panelists.